One moment driving, a life lost. When does an accident become a crime?
One text message, one moment of distraction, one poor decision behind the wheel. That's all it takes to face vehicular manslaughter charges in California. Every day, split-second decisions on the road lead to tragedies that don't just change lives. They can also result in serious criminal charges. Today, we're going to break down when a fatal accident becomes a crime under California law, what prosecutors have to prove, and how these cases are fought. Let's begin with the legal definition. Under Penal Code Section 192C, vehicular manslaughter is the unlawful killing of a person without malice, committed while driving a vehicle. The law applies when someone drives with criminal negligence or while committing an unlawful act that is dangerous under the circumstances. There are three forms of vehicular manslaughter in California. The first is vehicular manslaughter with gross negligence, when someone drives in a way that shows a reckless disregard for human life. The second is vehicular manslaughter with ordinary negligence, when someone fails to use reasonable care while driving. And the third is vehicular manslaughter for financial gain, which usually involves insurance fraud schemes staged to cause a crash. The distinction between gross negligence and ordinary negligence is one of the most important parts of the law. Ordinary negligence happens when someone fails to act as a reasonable driver would. For example, checking a phone at a stoplight that turns green or rolling through a stop sign without fully paying attention. Gross negligence is much more serious. It's when a driver acts with extreme recklessness, showing what the law calls conscious indifference to the consequences. Think of street racing, speeding 90 miles per hour through a school zone, or swerving in and out of traffic in a way that clearly endangers lives. That difference between ordinary negligence and gross negligence can mean the difference between a misdemeanor and years in state prison. To convict someone of vehicular manslaughter, prosecutors have to prove several key elements. They need to show that you were driving a vehicle, that you committed either an unlawful act or a lawful act done in an unlawful way, that this act was dangerous under the circumstances, that you acted with negligence, and that your actions were a substantial factor in causing another person's death. That causal link is absolutely critical. If something else caused the death and your driving wasn't a major factor, the case falls apart. Now let's talk about penalty. Vehicular manslaughter with ordinary negligence is always charged as a misdemeanor, carrying up to 1 year in county jail. Vehicular manslaughter with gross negligence is what we call a wobbler offense, meaning it can be charged either as a misdemeanor or as a felony. As a misdemeanor, it still carries up to 1 year in jail, but as a felony, it carries 2, 4, or 6 years in state prison. Vehicular manslaughter for financial gain is treated the harshest. It's a straight felony with potential sentences of 4, 6, or even 10 years in prison. And then there's DUI-related vehicular manslaughter, which has its own enhanced penalties. This is where the Watson murder rule comes in. Under a case called People v. Watson from 1981, if someone has a prior DUI conviction and later kills someone while driving under the influence, prosecutors can actually charge murder instead of manslaughter. That's because the prior DUI shows the driver already knew the risks of drunk driving and chose to disregard them. A Watson murder charge carries a sentence of 15 years to life in prison. You may be wondering, what defenses exist in these cases? One of the most common is arguing that there was no negligence at all, that the driver acted reasonably under the circumstances. Another is lack of causation. If something else caused the accident, say a sudden medical emergency, a mechanical failure, dangerous road conditions, or even the actions of another driver, then the defendant's driving may not have been the cause of death. A sudden emergency defense can apply if the driver was reacting to an unexpected situation in a reasonable way. In other cases, the defense may simply argue that the accused wasn't the one driving at all. Accident reconstruction experts often play a huge role in these defenses, helping explain how and why the crash occurred. To give some real-world context, consider situations like a driver texting behind the wheel and crashing into another car, a person falling asleep while driving late at night, or someone running a red light in a rush to get to work. Even seemingly minor actions like adjusting the radio or reaching for something on the floorboard can lead to vehicular manslaughter charges if they're done negligently and result in a fatal accident. The law doesn't just look at what happened. It looks at whether the behavior amounted to criminal negligence under the circumstances. Vehicular manslaughter charges are some of the most serious a driver can face because they arise out of tragedy. What may have started as an accident can quickly escalate into a felony case with life-changing consequences. That's why it's so important to understand how the law works and what defenses may be available. If you or someone you care about is facing a vehicular manslaughter charge, don't wait. The earlier you get help, the stronger your defense can be. Schedule a consultation today and take the first step toward protecting your rights, your freedom, and your future.
Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.